Order the public session of the State Ethics Commission on the 22nd day of June 2010 at 9 a.m. The minutes of the meeting of March 25th, 2010. Yes, Claire?
I'm sorry, I'm probably jumping again, but don't forget to read that, Sunshine.
Well, I thought if this is the executive session, I always read that.
No, you read it at the public. It does say about the executive.
Okay, I got you. With the start of this meeting, I am pleased to say that pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to the said executive session or at the next meeting thereafter. The executive teleconference meeting was held on April 19th, 2010, and an executive meeting will be held immediately following the June 22nd, that's today's meeting, to review matters that are by statute confidential. With that, the minutes of the meeting of March 25th, 2010 have been distributed to all commissioners as well as council. Are there any additions, corrections, suggestions to those minutes?
Mr. Fryman, just two. On page 3 of the public meeting minutes, toward the bottom, and Claire and I have talked about this, in the heading regarding the income maintenance caseworker's opinion, the last docket number should be eliminated because that was the one that was continued until today. And the second item I have is on page 5, toward the bottom, in the civil penalty matters. In item 2, Leo Sheehan was the respondent, and Lisa Kabunkel was not in that meeting. That was a prior meeting, so that should be removed.
Thank you. Are there any objections to these amendments to the minutes? I would therefore ask for approval of the amended minutes of the meeting of March 22nd.
Move adoption of the amended minutes.
Is there a second?
Second.
And there is. All those in favor, kindly respond by saying aye.
Aye.
Being there are no negative minded, the minutes as amended will be approved. Moving on then to the regular agenda that has been submitted. The second item, Tate, Beck, and al. Commissioner Bergen, I think that was a matter that you have.
Yes, I do. Facts pertaining to these appeals of advice are as follows. The subjects of these appeals, whom I shall collectively refer to as the appellants, are individuals employed as income maintenance caseworkers with the Pennsylvania Department of Public Welfare, which I shall refer to as DPW. The appellants have appealed advice of counsel 10-537. The advice of counsel determined that as income maintenance caseworkers under Job Code 44720, the appellants are public employees subject to the Ethics Act and regulations of this commission, and in particular the requirements for filing statements of financial interests pursuant to the Ethics Act. On appeal, the appellants argued that the requirements to file publicly available statements of financial interest constitutes a change in the conditions of their employment and presents an unacceptable risk of misuse of their personal information, as well as a violation of their privacy. Mr. Chair, I would suggest that this would be an appropriate time for any interested parties to speak on the matter.
This is an appropriate time, but as we observe the audience here, there seems to be no one that wishes to address the matter, so I will turn it back to you.
Mr. Chair, I've reviewed the facts and relevant statutory provisions. As the Commissioners are aware, in Ludwig Opinion 09-001, we determined that income maintenance caseworkers under Job Code 44720 are public employees subject to the Ethics Act and regulations of this Commission, and in particular the requirements for filing statements of financial interest pursuant to the Ethics Act. Our decision was affirmed by the Commonwealth Court in Quaglia v. State Ethics Commission, a ruling issued January 5, 2010. It remains to be seen whether the Pennsylvania Supreme Court will entertain an appeal of the Quaglia ruling. For the same reasons enunciated in Ludwig and Quaglia decisions, it is my view that the job classification specifications under Job Code 44720 are sufficient to establish the appellant's status as public employees subject to the Ethics Act. The assertion that the financial disclosure requirements of the Ethics Act violate a right of privacy has been considered and rejected by the Pennsylvania Supreme Court. Based upon my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. As DPW income maintenance caseworkers under Job Code 44720, the appellants would be considered public employees subject to the Ethics Act and the regulations of the State Ethics Commission. The appellants would be required to file statements of financial interest pursuant to the Ethics Act. Advice of counsel 10537 is affirmed.
With that motion, is there a second then?
Second.
It has been second. The floor is open to any discussion, comments, concerns, questions.
When do we expect a decision on that? The pending,
You just don't know, I would have expected it by now, but it's entirely.
maybe it's close?
Yeah, I would think so.
Any other questions? Seeing or hearing none, ready for a vote. All those in favor of the motion as presented, kindly respond by saying aye.
Aye.
Are there any opposed? And there being none, it is unanimously passed. Moving on the agenda to the civil penalty orders. Commissioner Bolger, I believe you have those.
Yes, I do, Mr. Chairman. There are 5 civil penalty default cases that are now before our commission for decision. These cases involve respondents Ronald Reese, Craig Hartley, Roy Hunt, Donna Gordy, and Pamela Shaw. These respondents did not file timely answers or respond to civil penalty proceedings. Following review, it is my opinion that as to each of these respondents, the commission should levy a maximum civil penalty of $250 for each delinquent or deficient statement of financial interest. For these respondents, the total civil penalty liability would be $250 per respondent. It is my opinion that the commission should also order all these respondents to file their delinquent or deficient statements of financial interest. There is nothing of record that would constitute a defense or excuse for their noncompliance. Based on analysis and my comments that I just made, I would like to make the following motion. I move that this commission level civil penalties against the following respondents in the amount of $250 each for failing to file statements of financial interest for 2008 calendar year as required by the Ethics Act and regulations of this commission. The 5 are Ronald Reese, Craig Hartley, Roy Hunt, Donna Gordy, Pamela Shaw. Further, these respondents shall be ordered to file complete and accurate statements of financial interest for the calendar year 2008 within 30 days of issuance of the commission's order.
With that motion, before I ask for a second, I would ask if there any commissioner that wishes to handle any of these separately or independently rather as a group. Inasmuch as there's no response to that, I will take a second to the motion for all of the 5 of them to be considered one time.
Second.
And there is a second to the motion. Further discussion, questions, comments from any? There being none, the motion is stated for the $250 penalty for the 5 as stated. All those in favor, please say aye.
Aye.
Are there any negative-minded? And there being none, they will be opposed. Thank you very much. Moving on the agenda again. John, you were concerned we wouldn't move this quickly enough? We're on the move.
Okay. As we just discussed, there were 5 default, and now there's 2 consent orders. So these cases involve respondents Joseph DeLuca and Francis Jones. The parties have submitted consent agreements proposing that the commission find that the respective respondent failed to timely file 1 or more complete and accurate statements of financial interest and impose 1 or more civil penalties with a direction to file. The respondents have already satisfied the terms of the consent agreement. Based upon review of the facts, and they've already satisfied the terms, I am of the opinion that these consent agreements are consistent with commission precedent and our proper disposition of these cases. Based on this, I would like to make the following motion. I move that the commission approve the consent agreements submitted by each of the following respondents and the investigative divisions imposing civil penalties for failure to timely file complete and accurate statements of financial interest for the respective calendar year as follows. Joseph DeLuca for calendar years 2005.